I think we're live. So,
Cool.
hello everybody. Today in this video, whatever, live, we're going to be what are we doing?
We're watching or listening to rather the Supreme Court hearing on the student loan forgiveness and the students who didn't qualify.
Yeah, I think that's what this one is. Yeah.
Okay.
Okay. Ready?
Yes.
Okay. And
we'll hear
you can hear
argument.
that.
We'll continue argument.
Yeah, you should turn it down a little
in case
bit,
20.
Let me. Oh, yeah. Okay. Maybe halfway.
Yeah, halfway might be good.
2535, Department of Education versus
Is that
Brown.
better?
Welcome back.
Maybe a little bit less.
Thank you, Mr. Chief Justice, and may it please the court. Across the board, Brown and Taylor's arguments in this case run counter to precedent and principle.
Try to
On standing, respondents' asserted injury is a complete mismatch for the relief they seek. They claim to want greater loan forgiveness than the plan provides, but they ask this court to hold that the HEROES Act doesn't authorize loan forgiveness at all. A win on that theory would mean that no one could get any HEROES Act relief. Not Brown, who would get nothing for herself, not Taylor, who would lose $10,000, and not any of the millions of borrowers who need this critical relief. Respondents lack standing to seek that result. Parties cannot go to court to make themselves and everyone else worse off.
Okay, now I just
to get around that problem, Brown and Taylor gesture at the idea that if the Secretary can't act under the HEROES Act, he might consider making an entirely different decision to grant debt relief under the Education Act. But on the merits, respondents are broadly attacking the whole idea of providing loan forgiveness under any executive action. They never explain why they think the Secretary could provide broader relief to even more borrowers under the Education Act. And in any event, this court has never endorsed that kind of circuitous route to standing. A plaintiff who isn't injured by agency action can't establish standing by speculating that invalidating that action might prompt the agency to take an entirely different action under a different statute. If the court reaches the merits, it should reject respondents' claim. They argue the plan is unlawful because the Secretary didn't use certain rulemaking procedures. But Congress specifically exempted the Secretary from following those procedures when he issues waivers and modifications under the HEROES Act. Respondents' procedural claim fails in light of that clear statutory exemption. I welcome the court's questions.
Are there any instances in which you would have procedural standing?
So I think that if they wanted to argue that the Secretary should have reconsidered his decision under the HEROES Act to grant broader relief, then it's possible that they could have raised both a procedural claim and a substantive claim, because at that point their injury would be redressable. They would be saying that the Secretary drew arbitrary lines, that the plan should be expanded to include them and to provide relief to them, and that would be a very straightforward route to making the arguments if what they really want is loan forgiveness. But instead, their whole argument here is that the Secretary can't give them or anyone else relief under the HEROES Act. And when you look at it that way, there is no case that we've been able to find, and we've really tried to boil the oceans here, that could plausibly support that theory of procedure.
All right, I want to look up the HEROES Act.
Okay.
Because they keep mentioning that.
I think that's the act that Biden used to do this. Or not, I don't even think Biden technically. I think he approved it, but I think someone else, I don't know. Yeah, you'll have to look into the HEROES Act and we'll see.
Oh, okay. So the bill responds to the COVID-19 outbreak and its impact on the economy, public health, state and local governments, individuals, and businesses. So it provides emergency supplemental appropriations to federal agencies, payments and other assistance to state, local, tribal, and territorial governments, additional direct payments of $1,200 per individual. So the stimulus expands paid sick days, family and medical leave, unemployment compensation, nutrition and food assistance, housing, and payments to farmers. So yeah, it's essential workers, tax credits and deduction. Yeah. And then it modifies a wide range of other programs and policies. So Medicare, Medicaid, health insurance, broadband service, medical products, supplies, immigration, student loans, financial aid, federal workforce, prisons, veteran benefits, consumer protection requirements, the U.S. Postal Service, federal elections, aviation and railroad workers, and pension and retirement plans. So it covers a lot of stuff in response to COVID, basically.
Yeah, I was like, I think it was due to like the pandemic, basically, kind of.
Yeah.
So, okay.
Injury. It would blow open the doors to asserting Article 3 injury when you are not directly affected by an agency action.
I put it on
and
my
by
computer.
your own lights,
It's
you can't
easier,
stand to
then I can
benefit
pause it
from any
quicker and
ruling
stuff.
on that agency
Like the
action
text is on my
merely
computer.
because you think that if you
Okay.
can block, you could, the agency might reach out and look for some other source of authority to regulate and make a new action.
This action has nothing to do with their right, if they thought it was permissible, to seek relief under the Education Act, correct?
That's correct.
They could-
It's a totally different source of authority. If they want relief under the Education Act, there are provisions where they can file a petition for rulemaking and ask for that relief right now. And it's not as though these are mutually exclusive sources of authority. The Education Act is not directed to national emergencies. It's not, it's an independent source of authority here, unlike the HEROES Act, which is the action they're challenging that's specifically focused on this agency, this national emergency situation.
I understand your argument on standing, and I know this isn't directly on point, but when I saw it, it's sort of like the equal protection cases, where discrimination between men and women on the level of pensions, and the women, the widows get more and the widowers get less, and the challenge is brought, and the argument was, well, if you win, we're going to take the excess away from the widows, so you're not going to get anything, so you don't have standing. Why is that case? I appreciate the way in which it's different, but why isn't that at least some authority on which they can rely?
I think that the equal protection cases are fundamentally different because there, your injury is your complaint of unequal treatment. And so whether you level up or level down, your injury is being redressed. You're no longer being subject to unequal treatment, and instead everyone is being subject to the same treatment. But this case stands in a very different posture because here, their argument is our injury is we're not getting loan forgiveness. And the relief they're seeking, which is a declaration that the HEROES Act doesn't authorize loan forgiveness in the first place, doesn't redress that injury one bit. It
Right,
just
but
carves it into stone.
Right, but I mean, without looking after the case, yes, you could lower it or raise it, but that's an uncertainty that we decided that did not affect their right to bring the action because it may be changed in a particular way. And I suppose their argument would be that, they are injured by not being participating in the program. And if the program is struck down in its current form, it may be changed in a particular way that would help them.
So I think that there is, though, a complete disconnect between the claim of injury. And it's true that in the equal protection context, you don't know ex ante what the remedy is going to be. But the court has determined that doesn't affect standing because either way, no matter what remedy occurs based on the equal protection injury, it's going to fix the nature of the harm of providing unequal treatment. And here, the only certainty is that if they prevail on their claims, it's going to make it harder to provide them or anyone else with debt relief. Their suggestion here that the Secretary wholly lacks this authority under the HEROES Act, and their assertion of arguments to support that claim that broadly attack this whole concept of loan forgiveness, I think demonstrate that we're far afield from the equal protection case law.
Can I just ask you, I'd understood them to be complaining about the procedures. Am I completely off base here? You suggested that they're complaining about not getting enough loan forgiveness or something. Maybe I misheard you, but I thought they were trying to bring a procedural claim, and that the reason why this was problematic was because the procedures that they are saying are lacking are actually under the other source of authority, that if we looked at the source of authority that the Secretary used, in this scenario, it doesn't guarantee them those procedures. So you can't really complain about not getting procedures in under another statute that was not invoked in this situation. Am I wrong about this?
No, and I understand the confusion because
Okay.
the theory here is a little convoluted. And so let me try to unpack it. They are asserting a procedural injury, but what they're saying is we want an opportunity to comment on loan forgiveness so it'll include us as well. Our underlying injury is that without having a chance to comment on the Secretary's use of authority under the HEROES Act, we didn't get a chance to advocate for us to be included in the plan. The problem with that procedural theory of harm is that by their own arguments in the case, the Secretary couldn't make a different decision. He couldn't go back to the drawing board and think about it and decide, yes, I'm going to expand the plan under the HEROES Act to provide these borrowers with relief too. So they aren't able to assert that kind of redressability for an asserted procedural injury under the HEROES Act.
And that's because there aren't negotiated procedures under the HEROES Act.
Right. The statutory text is very clear. So even if you were to get to it on the merits, they haven't actually been deprived of any procedural rights. The HEROES Act specifies that waivers and modifications issued under the HEROES Act are exempt from notice and comment. But I think because of the fundamental flaw with their theory of injury and the fact that it couldn't be redressed by their own arguments in this case, they've now brought up this Education Act idea. They haven't been deprived of any procedural rights under the Education Act. You know, procedural rights derive from specific agency decisions under agency authority. So it's not as though they have some procedural right in the ether to just comment on the concept of loan forgiveness writ large. Instead, under the HEROES Act, as we've just discussed, there isn't a notice and comment procedural right. And under the Education Act, no decision has been made. And so they haven't been deprived of any procedure associated with that decision making.
So what they would need, I suppose, is certainty that if we nullify the authority of the Secretary to do what it did in the HEROES Act, that there would necessarily be a loan forgiveness program under the HEA.
Yes, and they can't make anything like that showing here. It's total speculation on their part to suggest that if the Secretary is blocked from taking this action, maybe he'll look for a different source of authority and issue an entirely different program under that source of authority. And I think that that shows that their theory is unduly speculative here. I think it's important to recognize as well why they're pressing this claim and the upshot of this theory. The reason they're asking the court to go down this road is so that they can effectively raise a substantive challenge to the HEROES Act. That was actually the only claim on which they prevailed below. The district court in this case rejected their assertions of procedural harm and instead went on to resolve a standalone substantive challenge to the Secretary's plan and said that it was unlawful under the HEROES Act. But they've now entirely abandoned that basis for prevailing below. They say that the district court was wrong to consider that. They're not defending that ruling. And it makes good sense because they obviously lack standing to maintain a substantive standalone challenge to the HEROES Act, since that wouldn't do anything to redress their harm, but instead just ensure that they aren't going to get any debt relief. By raising this procedural argument, though, they're effectively asking for an opportunity to raise the very same substantive claim that they lack standing to pursue through the guise of a procedural challenge to the act. And there is no apparent reason for the court to allow that kind of gambit and to take what is actually a substantive challenge based on a generalized grievance with how the executive is administering the law and alter the ordinary Article 3 standards to allow a plaintiff to revisit that conclusion through a procedural mechanism.
General, I appreciate your standing arguments, and they've been laid out very clearly here. An interesting feature of this particular case, as you well know, is that the court entered a universal decree. We've chatted about this in prior cases.
We have indeed, Justice Gorsuch.
I would.
Yes.
So, okay, I just want to make sure I'm not confused here. So I'm assuming this is the person who's trying to not give them the loan forgiveness talking. That's what it sounds like. And
No, I think she's going like, you mean what's her name? The
one who's
lawyer.
not the lawyer, yeah.
No, I think she's arguing against them.
Right, that's what I'm saying. Yeah.
Oh, okay, yeah, sorry. I thought you meant she was arguing for the people
no,
against
yeah,
the, okay, sorry.
Okay, so is she saying basically they would have to like write a new like law or something or act into place to give them the loan forgiveness?
Well, she's saying
that's what it sounds like. And like because they can't under any current legislation. but they would have to make new legislation basically
Well, I think
for that.
her main argument is that they're, what is this called? They're like, what?
Like
Their
overall.
argument, I guess, maybe.
Oh, okay.
Their argument or like case, I guess their case doesn't really have any, shouldn't, from what I understand. Obviously, I'm not a lawyer, so I could be wrong. But from what I understand, it sounds like she's trying to say that their case doesn't have any standing because they're arguing for something that is gonna ultimately end up hurting themselves. Because I think there's two students, if I remember correctly,
Yeah.
and one of them did qualify. So by arguing this, she is, or he or she, I don't know the gender of the person, but
Yeah.
that student is going to lose the $10,000 that they are getting forgiven and may not get anything.
Yeah.
So if they overturn this, I guess their argument is that they want to overturn this so that then the person who forgave the loans will then forgive more. But
Yeah.
there's no guarantee that if the Supreme Court were to overturn this, that would happen.
Right.
So this student is basically hurting them. And I think they go more into detail about that too. But that's
Okay.
kind of what her main argument against their case is that
Oh, okay.
you can't really argue something that is going to like hurt yourself and hurt others. She explains it better, but that's basically kind of what it is that really in her understanding. And I guess like it makes sense to me too, because you got the 10,000. So now you're trying to take that away from yourself as well as everyone else in America.
It's
who
like
got that.
gambling.
Yeah, just because you think they might, and they probably wouldn't even do that though.
Right.
Like if we don't get this forgiveness, they're probably gonna be like, well, we tried, and then they're gonna like give up,
So did they already make the decision on this?
They might have made the decision, but they don't release it until July, I think.
Oh,
is
okay.
when all these like decision, like the one about the internet too. But I mean, we'll kind of see, I guess, with TikTok. If they ban TikTok, they also have provisions in there regarding 230, I think, too.
Yeah.
To make it,
I would assume.
which would, I think that'd be worse for the like free speech, because then they
Right.
would have way more control. I mean, the government doesn't.
Like, are you saying if they got rid of 230?
No, they want to like revive. We'd have to look into the if you look into the TikTok ban bill, which is what they're
Yeah.
like arguing with TikTok. I think it will. We can look into that too in a little bit,
Yeah.
just to like see what it goes over. But I think it gives like them more control on what is like the government more control on what's allowed on the internet.
Yeah.
So if they don't like something, then they can take it down, which
Right.
that's not free speech at all. But
Yeah.
so I think that's them addressing 230 instead of letting the Supreme Court do it. Like they're trying to legislate, like they should be legislating anyways, but not restrictively. But I don't know. We'll have to see, obviously, what. And I haven't like looked at it, so this is just from hearsay. So I don't know. I could be being fed propaganda too, So
Yeah.
that's why we'll look into it in a little bit. But
Okay.
we'll keep.
Just wanted to give you another
going in.
chance to talk about universal vacature with some of my friends here, if you want it. And if you don't, that's fine.
I will always take that opportunity. We did argue below that the district court didn't have authority to enter universal vacatur in this case. And, the language that courts have relied upon in thinking that this is a permissible remedy under the APA.
For a handful of plaintiffs.
Yes, for two individual borrowers. Is the set-aside language. But as we've explained, that language, which comes from Section 706 of the APA, if you look back and trace through what Congress was doing when it enacted the APA, was not meant to be the remedial provision of the APA. Instead, that comes from Section 703, which tells you to either look at a special statutory review provision if one exists, and sometimes there are special statutory review provisions that say you can operate directly on the agency action at issue. But in the absence of that, then it's the traditional equitable remedies that predated the APA, and there was nothing like this universal vacatur remedy then, which would take you far beyond party-specific relief.
I mean, talk about ways in which courts can interfere with the processes of government through two individuals in one state who don't like the program can seek and obtain a universal relief, barring it for anybody anywhere.
That's right. For millions of Americans, they've been able, on the basis of this claim, to hold up that critical relief.
But of course, if they actually had standing to do that, then, they could bring such a claim. And I guess your position, which is not in this case, because we don't have a question presented about universal vacatur, but your position is that the court doesn't have the ability to issue an injunction that would prevent this plan from operating just because it was two people who brought the claim originally?
Well, to be clear, we're not suggesting that injunctions would be off the table, but those two would have to be targeted to party-specific relief.
And how would it be targeted in a plan such as this?
So, for example, if in fact they had standing to pursue a procedural right, then the secretary would be enjoined to provide them the process that's due and to take into account their views in determining whether to expand eligibility under the program. But nothing about that, Justice Jackson, would in any way call into question whether other people should get this relief.
I understand, but would you have the same reaction to universal vacatur if the claim on the table was about their particular entitlement to getting, let's say, more money under this plan? Would we be in a world, if you were right about universal vacatur, in which every single borrower in the country would have to bring a lawsuit in order to vindicate a right that the court would say these two people have?
Well, I think in a situation, it depends a little bit on which court you're talking about. Obviously, this court has the authority to resolve issues like that for the entire nation. So if a question makes its way to this court, then it wouldn't be necessary to have follow-on suits. In the absence of that, then yes, our argument is you should provide party-specific relief, that the traditional concepts of remedial authority under Article 3 were limited in that way, and that to instead allow single district courts throughout the nation to claim the power to put a critical policy on hold is out of accord.
So I recall that the last time we did this, every member of the DC Circuit.
We can go into this, but.
So I'm just going to change the subject of.
General, I'm sorry.
I relieve Justice Kagan, thank you.
Because there are many
go back.
many former members of the DC Circuit.
I'm going back.
I'd like to hear about the merits of this case. I want to come back to some of the claims that both sets of respondents here have in common, dealing with what we've called the arbitrary and capricious aspects of the case. And as I understand it, the memorandum really talks about two things. It talks about forbearance, and it talks about sort of economic/COVID conditions. Forbearance as a kind of separate thing, that people who have been granted forbearance for long periods of time are more likely to go into default or become delinquent in their payments. And I guess I wonder, is that about COVID, or is that just about something that happens when you excuse loan payments for a long period of time, and how it is that gets to be converted into an emergency COVID rationale? And then on the economic considerations, and I think it was Justice Barrett who talked about this a little, it seems, a real mixture of COVID and non-COVID related things. Of course, this is how the economy works, that COVID interacts with other features of the economy.
Yeah.
I mean, like, people might not be able to pay off their student loans because, hold on. They might not be able to pay them off because they lost their jobs because of COVID, or they had to work from home, or they got a pay cut because their hours got cut or something. Like, I mean, there's a lot of ways that this is related to COVID.
Yeah, for sure. I don't know. I guess what she's trying to. Yeah, and I guess I don't know really about the excusing pay, like that. I feel like that really doesn't affect, like, I feel like they're trying to say that is, like, I don't know. I guess I don't understand that part, because I don't think it's like pushing these loans off was obviously necessary.
Yeah.
It would have, especially during COVID when people were losing their jobs and were getting evicted, and like, how would you have expected? Like, obviously this would have hurt the economy more if people had to pay, because this, I don't know, people also think that
Right.
I feel like the loans, if we forgive these, then like that, this would be one of probably the biggest helps to the economy, because the money that they would have spent paying back those loans is going to be spent into the economy. Because
Yeah,
but us paying back
exactly.
those loans isn't going to help the economy. It doesn't help anyone. I don't know why people think
Right.
that forcing people to pay back these, like, I get it. I get it to an extent. Like, yes, if when you take out a loan, you should plan to pay it back. But these were also, most of student loans are very predatory, and
Yeah, they have super high interest rates too,
yes,
don't they?
yes, I think it sounds, I'd have
In
to
the
look, but I
20s.
think Biden set it to a fixed low rate. I don't know for sure, but or it sounds like that's what he wanted to do. I don't know if he did, but either way, it should be like zero. Because why would
Right.
you have interest on it anyways?
Right. And I mean, some people might say, oh, like we want to account for inflation, but like, I mean, you could put like no more than like 5% though. Like if you are going to put an interest rate on it, I would say definitely not more than like 5%.
Yeah, and I mean, what, like, this is to encourage people, like in my head, these types of loans from the government are to encourage people to go to college. So why would you want any, like, and again, when they pay this money back, nobody's benefit, nobody benefits. Nobody gets this money. The government doesn't get the money
Right.
because the government doesn't need money. The government has as much money as it
Yeah.
wants.
Yeah,
And
they
then
can print more money.
yeah, I know people think that will cause inflation, but it won't. It could, but it's
Uh,
by itself, it's not going to cause inflation.
Yeah, like I think it just depends how you go about doing it.
Yeah, and it depends on what you spend it on, because
Yeah.
resources are important. Resources are going to, if there's a lack of resources, and people are resources, money is a resource to an extent, not to the government though, because they have a fiat currency. They
Yeah,
can print as much
especially
money as they want. So that's
yeah,
not really
especially
a resource to
resources.
them. But yeah, resources like
Yeah.
steel, or like if you want to build something, you're going to need people and steel and whatever else you need to build certain. So like the resources
Yeah.
matter. Like we can't just print billions of dollars thinking that we have
Right.
unlimited
And then,
resources. We don't have unlimited resources, but money is unlimited for the federal government. It is.
right. Like if we're just spending it on like the military and all that, like
Well,
that's
that's why
not
they don't
gonna
ever
help the
worry.
economy.
Well, that's why they don't ever worry about cutting. I'm pretty sure a budget plan that I saw recently proposed, I think by like the Republicans, because they're talking about the budget. They cut everything, but then put a 1% increase on the military.
Oh
Although
yeah.
they, of course they did, but
Because
either
that
way,
was just their plan, right?
well, and I think yeah, but I'm pretty sure Democrats would also be for that, because to them the like I don't know, they are so into the which I get to an extent, but it doesn't really. We don't need to be spending as much as we do, but we
Right.
can
And
too,
like
because the money doesn't matter. But they're claiming that we have to cut like social security programs to fund we don't. That's just a
right.
joke. This
It's
whole
ridiculous.
budget thing
And
is a
like
joke. No, we don't. The American government, federal government, does not need to budget.
and like it wouldn't even be so bad with the military spending, but like we just spend it on so much waste that like we don't even use. We spend billions of dollars on like tanks that we just blow up or abandon in the Middle East, like and never use.
Yeah, and I mean
Yeah.
that would come down to like the resources used to build the tank. Like those resources are
And
obviously
those
going
are
to run
like
out
private
eventually.
those are private companies that do that though. And then
Oh yeah, I
they
think
charge exorbitant rates for
what are those
anything related
called?
to the military.
Isn't there only like two? Don't they have like monopolies on the government industrial
I
militarize?
I think so, yeah.
There's only like 2 or 3 that are big
But, like
families that have been doing it forever with the government paying them
pretty
money.
much.
So that's
Pretty
not
much.
like a surprise. Like that's basically like a government handout to them just to give them
Yeah,
stuff too. But people
basically.
don't
I
want to talk
mean
about that because safety, even though we spend way more than any country,
right.
like too much, but it's fine. It's whatever. That I don't. As long as we can fund the military as much as we want and still fund these social programs. So when they're going around
Yeah.
trying to cut Social Security, even though they claimed they wouldn't, in their proposal, I'm pretty sure there was like a 5% cut or something, which maybe to some
Oh
people
wow.
is like, oh, that's not that, but you
That's
don't
a
need to
lot of
cut
money.
any of these Social
And
Security
then they wanted
programs.
to cut like what 49% of like
Medicare.
Medicare or
Yeah,
Medicaid or whichever one. Yeah,
like that's a
and
joke.
yeah, like healthcare for kids. You know, I think it was a chip. It's
Oh, it
something.
might have been. I'd have to relook at it, but
And that was part of the 49% too. Like
that's
healthcare
like,
for kids. I didn't get the
uh,
healthcare. It's something for kids.
yeah, I think one of them. But yeah, it's just ridiculous because none of, like, they could fund it all just fine, but then there are all
Yeah.
these people in Congress who probably don't have any idea of how anything runs are always like, we need
Yeah.
to stop this unnecessary spending, but you don't have any unnecessary spending, not necessarily, unless
Right.
we're running out of resources. But we're not running out of money because you guys can print as much money as you want. So it's
Yeah.
not the money that is running low. So if there's an actual resource that is running low, then that is something that you can talk about with the budget. But money is not something
Right.
that
And I mean,
is going to run out. It can't.
like what there was. I don't know if last year you did, but I know there was like 1 or 2 years at least where like Jeff Bezos didn't even pay money in taxes at all.
Well, yeah.
I mean, like, if you don't want to print more money, if you want an alternative option, let's just say there's a few people that could pay a little bit more in taxes.
Well, they won't do that. That's who funds them. That's who funds
Right.
their campaigns.
Oh, I know, but just saying, if you don't want to print more money, it's an idea. If you're so
Yeah.
scared of the inflation. Okay,
Yeah,
I'm
it's
gonna
just-
move to my room really quick.
Oh, okay. Sounds good.
Okay. Man, let me just turn on the light. So
Okay.
when it gets dark, I'm not like all that.
Okay. Should we get back to it? To these guys talking?
Let's do it.
Made to produce certain economic conditions. But again, I'm wondering whether, there was more of an obligation on the part of the secretary to isolate how COVID was affecting these borrowers.
Of course, and I'll take each of those considerations in turn. I'll start with your questions about forbearance. And I want to be really clear because I think my friends have confused the issue about this a little bit. But the secretary wasn't finding that forbearance itself had caused the economic harm to borrowers or that it was the root cause of why they needed additional relief. Instead, the secretary analyzed the historical data regarding forbearance as a data point in understanding that forbearance is not always a complete solution to the underlying economic harm caused by the national emergency. So here, there's no doubt that forbearance has provided very powerful and critical support to borrowers over the life of the COVID pandemic. But the secretary found that once forbearance policy lifts, millions and millions of borrowers are going to be worse off with respect to their ability to pay because of COVID. The forbearance policy hasn't fixed the underlying economic harm of the pandemic and the emergency. So to the extent that there's a bootstrapping concern here, I just want to push back forcefully on that. I think that the secretary's decision memorandum makes clear that sometimes additional relief is necessary, not because of forbearance, but in spite of forbearance. To turn to your question about the various causes or influences of economic harm here, it's of course true that I can't make a representation that the harms that borrowers are facing are solely due to COVID-19. But I think that it would be an impossible burden to place on the secretary to suggest that he needs to isolate and identify just one economic factor or force that's causing that kind of distress for borrowers. You know, our economy is very complex, and there are often multiple factors and forces at play. But the secretary here found, and I don't think that anyone could reasonably dispute, that but for COVID, borrowers would not be in this situation of facing severe financial harms and the very real risk that they'll have to go into default or delinquency when they start repaying their student loans. So I think to the extent that there's concern here about how the standard could operate, at the very least, the secretary made the requisite findings that these are financial harms that derive directly from and are a but-for result of the COVID pandemic.
Counsel, I'm sure I'm misreading the graphs I'm looking at 247, 248. Didn't half the borrowers say they would not have any trouble paying their loans without regard to the forgiveness program?
So it varies based on income bracket. And yes, it's true that in certain income brackets, the data, I think, reflected that, 51% of borrowers expected that they would be unable to pay their student loans. That wasn't the only data the secretary consulted, though. In those same studies that he referenced, there was general data about levels of financial insecurity, and overwhelming majorities of borrowers expressed huge financial insecurity concerns about their ability to make ends meet going 10 years into the future. And I think one of the important things to recognize, again, as I had mentioned in the last argument, is that it's not necessary for the secretary to make a finding that each and every borrower who receives relief under this plan would have necessarily gone into default or delinquency without it.
No, of course not. But I mean, it does kind of factor into the consideration, particularly in a situation where you don't have notice and comment proceedings, that maybe, again, that's something that a broader representation of national interests in Congress would take into account, rather than what the secretary in a particular case, who's weighing a lot of options and considerations as well, would take into account. I mean, if more than half the people say they don't need this relief, extending relief to that breadth certainly raises questions.
So let me be clear that I think there is an avenue to address.
So just because some people don't think they need relief doesn't mean that they shouldn't get relief anyways.
Yeah, because it would still help them. They would be better off if they get the relief. Whereas if they don't get the relief, that's going to lead to them being worse off. Even if they know that they probably can pay it, the relief will help them 10 times more than no relief at all.
And it'll help the economy ultimately too, because like you said, that money's going to go back into the economy instead of, into the
to nothing.
Just
like it literally goes nowhere. Back to the government, but the government doesn't spend our money.
Yeah, and it doesn't need
anyways. No, it doesn't.
And I mean,
the economy.
There shouldn't even be student loans in the first place. Like education should be free. Yes, because if we truly wanted to be the best country in the world, although I think that's a stupid goal, I think we should just be good over. I don't think we should try to be better than anybody. We should just all be good, because we in a good, I just feel like trying to be better than others makes other countries seem less, but no other country is less than. But I think it's good for us to want to do good for ourselves, I guess, is what it would be. But education should be free so that our country can thrive, and that would help the economy so much if people were able to attend college without the worry of debt. Yeah, and it would help with a lot of industries who are looking for people, such as the medical industry. It would help, it would actually, if we really want to be, a meritocracy where, everything's based on how hard you work and all that. If we want to get as close to that as possible, we need to have an even playing field. And it's not an even playing field when one family lives in a $5 million house and their kids go to college, and then someone else lives in an apartment paying $500 a month. And obviously they're probably not going to be able to afford to pay for their kid to go to college. And so, I mean, some people can get loans, but not everybody qualifies.
No, that too, and that's just another way the rich kind of run how the world is, how America is, and that's just wrong.
Exactly.
I don't even, because I guess what from the inception of higher education, was it ever free? I guess I don't know the history of higher education in college.
I don't think it was ever free in America.
Okay.
I'm not 100%.
But obviously
I
the
don't think
cost
it
was way lower. That's
Oh,
also
yeah.
another big factor too, is that the cost of education has been rising unnecessarily.
Yeah.
It hasn't improved at all. Like if you were to
Yeah,
compare, I'm pretty sure there's been maybe studies or something that show that like the quality of education hasn't necessarily improved comparative to the cost, to how much it has increased. Like there's not like a
Right.
correlation between that at all.
I
It's
mean, if
just
any,
pure greed.
yeah, and if anything, like they might use the excuse of like, oh, we're building a new swimming pool or we're building a new arena. Like, okay, I mean, that's cool, but it's not really necessary when you're charging this much. Like,
No.
you
And
should
it
just be
doesn't,
charging less and not building those things. And it
yes.
doesn't even all go to that. There's
And it
still
doesn't improve the outcomes either. Like a new
Right.
pool isn't gonna make you have better
education.
grades or
Yeah.
education outcomes. It's just like
Yeah.
it's unnecessary money. Like how about that not country but city can build a pool themselves with like city funds in the school, like
Right.
and then they can raise the money for that if they really need a pool. But then
Yeah,
because
they
it's not
can
even
find
like a
a
city,
yeah.
like only the people that attend college can go to that. If they're talking about, oh, it will help improve health outcomes, but only people who
Only for
pay for your college
Right. It's like,
can
yeah,
use
no.
that pool. Well, I think there may be some, like I think maybe USD, like I don't remember if their pool like non-college students could use, or maybe they had to pay. Like you could they probably charge like a membership fee for non-college students too. But again, that's just
Yeah.
them getting more money that they don't
Right.
need, because that's not the point of college, to build a
Right.
pool. It's to
Right,
help
exactly.
educate people so that they can help the economy, I guess, because that's what
Well, and
most
then
people bring it
with
back
the
to. But
pools and arenas and basketball courts, like of course they're gonna build that stuff because if you're part of the what is it, the NCAA, for example, like your school's getting a lot of money from that.
like
Like
sports,
yeah, like D1
sport.
sports. Like they get a lot of money and then they don't pay the students because they want the students to pay. Or like sometimes they'll get a scholarship if they're lucky.
Yeah.
But
even then like I don't know, that's just like a joke too. Like
if you can give people scholarships, why wouldn't you just give everyone a scholarship and make the education free?
yeah, that's very like, favoritism and like I don't know, it's just a joke, I guess, really. But
It is.
we'll keep and I guess so far I'm not like, I get they're trying to, like, they have to try to tear apart the arguments, but
Right.
I'm disappointed in the judges right now, but that's okay.
Yeah.
We'll see if they maybe redeem themselves. And I mean, they don't have to, I guess. It's their court, it's not, I don't really, but I
Yeah.
mean, they should listen to the people, because at the end of the day, the government serves the people. I think the government forgets that sometimes. Like, the government doesn't
Yeah.
rule
Of
us.
course
The
they
government
forget.
isn't a ruler. The
They're not
government is
supposed to
for
be.
the people. Yeah, they're not supposed to be. So, like, we just as people can't forget that. Like, they don't
Yeah.
rule us. They can help guide us because that's what they're elected to do, but they don't rule us. They can't. They're not supposed to, yes, but
Yeah, like it's in the Constitution. We the
it's
people.
for the people.
Right.
It's not for them to be monarchs, because that's exactly what the founding fathers would have not wanted at all.
Yeah, and it's basically like an oligarchy at this point with, a few businesses that tell politicians how to legislate.
Yeah, and I'm pretty sure I saw somewhere that also made me kind of start to realize we're not really, like, I mean, you can say we're a democracy, but I feel like if you need money to become a politician, then we're not really a democracy. But
And I mean,
basically, to run for office, I think for senators, you need $1 million to run, just for the ad, because
Yeah.
basically your like to campaign for yourself. So it's not that you need, like, that's not a requirement. Like, you can run if you don't have money, but if you're gonna get elected, you need the money so that you can
Right.
campaign, so that people can get to know your name and your face, and
Right.
because otherwise your competition will just spend billions of dollars to get themselves on every screen every 2 seconds, so that people
Yeah.
just keep seeing their face over and over, and they're like, oh yeah, that's the candidate that I want. That's the so
And I mean, like
it isn't
Bernie,
fair
like,
either.
like Bernie does it right. Most of his funds, from what I understand, come from people, everyday people who donate, not like large companies. And like that's how it should be for every candidate,
Oh
Like,
yeah,
I
100%.
don't even think companies should be allowed to donate to campaigns.
No, I don't think they
Like
should
if,
either.
if
That's
an
a joke.
individual wants to under their own name,
Yeah,
that's fine. And there should be a limit on how much each individual can donate
yeah.
as well. But yeah, like yeah, it should not be just corporations funding campaigns.
No, because then again, we're still
terrible.
that's not a democracy either. That's
Right.
corporations deciding how the government runs, and that's not how the founding fathers would have intended it either.
And then there's gerrymandering on top of that. That
Well,
definitely
yeah.
interferes with the democracy as well. Like, oh, I'm going to draw these lines so that smaller group of people gets more of the vote so that I can win.
Yeah, that makes it not for the people either. Which again, that just makes the whole
like it's
government turned into what the founding fathers would not have wanted it to turn into at all.
Exactly.
I'm pretty sure a lot of the founding fathers were actually against political parties too, because they felt that they would be the ruin of democracy, and I think they are, because all it does is divide people. But that's part of their point too. Really, Democrats and Republicans are honestly no different between them. Like there are differences when they speak, but their actions seem pretty aligned with like corporate interests.
There's a few small social differences maybe, but like ultimately they're both, promoting capitalism.
Yeah. Like they may claim that they are progressive, but then their policies would say otherwise.
And there's one or two candidates who are against capitalism, but like ultimately they don't have the power to get rid of it on their own.
Yeah.
I mean, they do have an influence. Don't get me wrong. They definitely have an influence on the parties that they run in, but like, I mean, the Democratic Party, but
yeah. And I guess it just takes, we just have to keep telling people, I guess that's what you just have to keep, they just have to keep being active and more proactive, unfortunately, than some of the other politicians who get elected and just sit in office and don't ever do anything, because half of them probably don't even write their own bills because of that ALEC thing. But
oh my god,
it's fun learning, but we'll keep listening.
Those kinds of questions with overbreadth. I don't think that it's a function of statutory interpretation, though. That would be applications of the statute to particular fact patterns and whether the secretary could justify the lines he drew and the level of relief he decided was necessary. And here, Secretary Cardona explained that huge numbers of borrowers were going to go into default and delinquency, and it's not as though he could easily segregate and say, here are the 50% where I know for sure it will happen, and here are the 50% where it won't. If you could make that kind of determination, it might provide a basis to determine that he should have drawn different lines. But we don't have anything like that here. And I would just point again to the forbearance policy. That has applied across the board to every single student loan borrower with a federally held loan for the past 3 years. But I think that both secretaries acted entirely within the domain of the HEROES Act and recognizing that that kind of broad class-wide relief was necessary due to the particular exigencies of this emergency.
Thank you. Since we're dealing in a case with individual borrowers or would-be borrowers, I think it appropriate to consider some of the fairness arguments. You have two situations. Two kids come out of high school. They can't afford college. One takes a loan, and the other says, "Well, I'm going to, try my hand at setting up a lawn care service," and he takes out a bank loan for that. At the end of 4 years, we know statistically that the person with the college degree is going to do significantly financially better over the course of life than the person without. And then along comes the government and tells that person, you don't have to pay your loan. Nobody's telling the person who is trying to set up the lawn service business that he doesn't have to pay his loan. He still does, even though his tax dollars are going to support the forgiveness of the loan for the college graduate who's now going to make a lot more than him over the course of his lifetime. Now, it seems to me you may have views on fairness of that, and they don't count. I may have views on the fairness of that, and mine don't count. We'd like to usually leave situations of that sort when you're talking about spending the government's money, which is the taxpayers' money, to the people in charge of the money, which is Congress. Now, why isn't that a factor that should enter into our consideration under the major questions doctrine again, where we look at things a little more strictly than we might otherwise when we're talking about statutory grants of authority, to make sure that this is something that Congress would have contemplated?
So my reaction to that, Mr. Chief Justice, is that Congress did take those kinds of considerations into account in specifically providing this authority to the Secretary. I think that the same kinds of arguments.
Well,
about
it's just
fairness
circular. It sort of begs the question to say that first, I don't see any evidence that they took the person who's trying to start the lawn service because he can't afford college. I don't see any evidence that they took him into account.
But if that's what Congress would need to take into account and show, then it can't legislate. It can't provide the executive with pre-authorization to take action into an emergency. Congress can't look ahead to the future and say, okay, in the year 2020, when an unprecedented global pandemic hits, we've decided that the lawn care professional should, not benefit from this program, but the student.
So, and yet you're relying
should.
you're relying on an interpretation of the statutory authority to say that that's implementing Congress's intent to do that in a pandemic that they couldn't have foreseen. We do think, no, they would have foreseen the idea when they said modify or waive, that would mean waiving the whole liability for 40 million Americans at a cost of $500 billion, that they foresaw that enough to allow the Secretary to act without any express congressional authority, any more express congressional authority than the authority you rely on.
Well, let me break it apart into two different components, because I think there's a first order question of whether Congress could have foreseen the possibility of debt discharge at all. And I think the answer to that has to be yes. That was a well-established form of relief that you can provide to borrowers in hardship situations. As I previously mentioned, it's one of the core provisions in the Title IV, and Congress, in specifically enacting a statute that's aimed at this problem of not leaving borrowers worse off in reaction to a national emergency, clearly understood that using this broad language. So that's the first order question. I recognize.
I'm not faulting you for repeating your answer, since I think I probably repeated my question. But you're just saying, it's the same argument about what modify and waive means.
It is as a statutory matter on the categorical argument about debt discharge. Now, you have asked me several questions about the scope of this program, and let me try to be responsive to that. I recognize that this is a big program, but that's in direct reaction to the COVID-19 pandemic, which itself was a really big problem. There hasn't been a national emergency like this in the time that the HEROES Act has been on the books that's affected this many borrowers. And so I think it's not surprising to see, in response to this once-in-a-century pandemic, the kind of relief that the secretaries have offered here, the forbearance policy that has itself cost $150 billion, and now this loan forgiveness program. To the extent that you have concerns about the scope and size of the program, though, I would say that if I can get you to agree with me, and maybe I can't, on this point that the categorical debt discharge argument doesn't work as a statutory matter, then I think the right place to look to house those concerns is an arbitrary and capricious review. We think here that the Secretary drew reasonable lines in crafting the scope of relief, but if you disagree, or if you think he should have taken different interests into account, that would be a basis to reverse him on arbitrary and capricious grounds, not to distort the plain meaning of the HEROES Act.
Thank you. Justice Alito?
Well, the Secretary did what he did. So presumably he had and has a view about the fairness question that the Chief Justice posed to you. What is that view?
So the Secretary understood the statutory authority and mandate here to focus on whether this national emergency was going to leave borrowers worse off because of the pandemic. This is Congress deciding that the government should be in a position to provide benefits solely within the context of the student loan program. And I don't think there's any part of the statutory analysis. This is Congress's judgment that borrowers should be able to get relief if the Secretary makes these determinations, with no suggestion that the relief should turn on or off based on the possible impacts on those outside the student loan program. Congress obviously knew when it was giving this authority to take care of borrowers who are otherwise going to be worse off that might have otherwise impacts outside the program, but it wanted to make sure the secretary could provide relief to borrowers.
Was the secretary legally obligated to do what he did?
No, he's not required to provide relief
All
under
right,
the
so
HEROES
he
Act.
decided to do what he did and must have had reasons for doing it, and some of them are on the record, some may not be. But the secretary, if you're right, then the secretary presumably could do more. And therefore, I think it's a fair question to say, what is your client's view about the fairness question that some people have posed, and that was reiterated for you by the Chief Justice?
The view of the department is that this
Why
relief
is it
is
fair?
warranted.
Why is it fair? If it was just, if he didn't have to do it, why is it an answer to say that it was warranted? Maybe it was warranted, but why was it done? I guess you don't want to answer the question.
It was fair because in the absence of this relief, it's undisputed that there are going to be millions of student loan borrowers who are not going to be able to pay their student loans, who are going into default and delinquency. And the HEROES Act was specifically designed for this situation. This is Congress telling the secretary, you don't have to let that happen. And when we have this kind of a pandemic that requires this kind of relief, I think that the HEROES Act is operating right within its domain.
All right, I'll try one more time. Why was it?
So my blood sugar's low. So are you down to take a little break real quick?
Oh yeah, we can. Yeah.
Okay, cool.
Hold on. Okay, we'll be back. Okay. I think.
Oh, do you see me?
No, I don't see you, but I can hear you.
Yeah, my camera's not working.
Oh, interesting.
What should we do?
I don't know.
I
Did
guess
you?
I can try my MacBook camera. It's not gonna look as good, but it'll still work.
Oh, yeah. I was gonna say, did you try turning it off and turning it on again?
Yes. I could try it. Let me plug it.
Yeah,
plug
I
it
don't
in.
know. Okay.
Nice.
Oh, there we go. Okay. Okay, cool. Ready?
Yes.
Fair to the people who didn't get arguably comparable relief. Now, it may be that their interests were outweighed by the interests of those who were benefited, or they were somehow less deserving of solicitude. But what is your answer to that question?
My answer to that question is that Congress has already made the judgment that when there is a national emergency that affects borrowers in this way, the Secretary can provide relief. And you could make this critique of every prior exercise of HEROES Act authority. There too, you could say, well, that only benefits the specific enumerated affected individuals, but it's Congress who defined those individuals, and the Secretary acted properly here in giving them relief.
Justice Sotomayor?
I take the bottom line answer to be everybody suffered in the pandemic, but different people got different benefits because they qualified under different programs, correct?
That's right. There's been enormous relief efforts.
There's inherent unfairness in society because we're not a society of unlimited resources. Every law has people who encompass it or people outside it, correct?
That's correct.
And that's not an issue of fairness. It's an issue of what the law protects or doesn't.
Yes.
Justice Kagan?
Congress passed a statute that dealt with loan repayment for colleges, and it didn't pass a statute that dealt with loan repayment for lawn businesses. And so Congress made a choice, and that may have been the right choice or it may have been the wrong choice, but that's Congress's choice. And you're saying that the Secretary implemented his powers under Congress's choice, which gave him authority over loan repayment. It definitely did not give him authority over loans for lawn care.
That's correct. The Secretary would have no authority to act outside the student loan program. The HEROES Act is specifically designed only to empower the Secretary with respect to that portfolio.
Maybe, as Justice Sotomayor said, Congress gave a different kind of authority to a different Secretary with respect to a different set of activities when an emergency struck. Is that correct?
Yes.
Justice Gorsuch?
I just wanted to make sure I understood your position with respect to some of the gnarly language in this statute, which is waive or modify affected individuals to ensure they're not placed in a worse position financially because of the COVID crisis. You'd agree that doesn't authorize the Secretary to place persons in a better position than they were because of the COVID crisis.
So I agree that the purpose is to ensure that they're not worse off, but I would disagree insofar as it's clear that he can provide class-wide relief. So if it turns out at the end of the day that some individuals are getting relief who it turns out wouldn't have needed it, Congress tolerated that and in fact encouraged the Secretary to err on the side of over-inclusion.
So you read this statute as not just authorizing the Secretary to place people in the same position that they were prior to an emergency, but to allow the Secretary to place persons in a better position than they were prior to the emergency.
No, I'm sorry. Let me try to clarify. His purpose has to be to ensure that they're not left worse off.
But his effect can be.
If the effect is that some individuals in the class receive relief who wouldn't otherwise need it, that doesn't mean that his plan is invalid. But if I could respond to your question about better off, worse off.
Let me just, I'm sorry, let me pose a different question. So some persons can be better off, is your position. I guess how many is my next question, right? Let's say two people in Missouri, okay. All right, they're better off, fine.
Why would you even be against people being better off?
That's what I was thinking too.
That's pretty messed up, in my opinion.
Right.
Regardless of your, I mean, granted, the Supreme Court shouldn't they should be apolitical. But regardless of your political beliefs, we should want society to be better off. That
Right. Like, oh
would be
no,
a
people
whole
are gonna
goal.
be better off. And so I think some people just have this mentality that like if other people are better off, then you're automatically gonna be worse off. If you're in a higher position of power, for example, in this situation. Like if the people in a lower position of power gain more money, which is power basically, you know, if they're better off in that sense, like it's not like it takes away anything from you.
Yeah, even though they,
People seem to think that way.
yeah, and like, I don't know if that's like your argument to churn down. So then you're making people worse off. If the Supreme Court overturns student loan forgiveness, then they are going to be making people worse off.
Yeah. And
But
that's going to make everybody worse off at the end of the day.
yes. We'll see what they have to keep saying, though.
But
Yeah.
what if it's 90% of the class, just hypothetically? That could the secretary do that under this statute?
So I think the right way to analyze that would be under arbitrary and capricious review, because as I've just explained, we think the statute tolerates some overbreadth. And so at that point, you would want to look at the secretary's justification for his action. It sounds to me like that could be unreasonable, that maybe he wouldn't be able to justify that particular line drawing choice because it would be so extensive relief that isn't actually necessary. But one of the things you'd want to look at is whether there was a way to tailor it, whether there was a way to segregate the people who actually needed the relief or not.
I understand that.
And just in case you think this plan does that, Justice Gorsuch,
No.
it does not.
I'm asking a hypothetical, and I understand your point. You direct us to arbitrary and capricious review. With respect to the fairness question that the Chief Justice posed, would you direct us as well to maybe State Farm, for example, where the Secretary has to weigh not just the benefits to the persons he's acting to favor, but also the cost to others?
I think that is a more natural way to analyze those issues. I should emphasize, because we're in this case,
You'd
that
agree
these
that-
individual borrowers didn't raise a State Farm
I know that.
argument. So they're not making these fairness allegations.
I hear you, but you'd agree that that would be a relevant consideration at some stage in a court's analysis of the Secretary's action.
I don't think that the Secretary could be faulted for not considering the interests of non-student loan borrowers, because I don't think that's one of the relevant interests that Congress expected him to take into account under this authority. As we've been discussing laws all the time.
It's just irrelevant.
Yes, I think that his charge under the HEROES Act is to determine whether student loan borrowers need this relief.
I appreciate. Thank you. That's clarifying. Thank you.
Justice Kavanaugh?
Private.
Pick up.
Yes.
So, okay. You know what I would say? Like, I mean, obviously not for this case specifically. They're just in response to like what he's saying about, oh, well, what about these business owners who didn't get loan forgiveness? Why not give them loan forgiveness too?
Yeah, but
Yeah.
I mean, like, I agree with that. But obviously, like, that isn't within the like that's not within his scope. With this HEROES Act, he couldn't do
Right.
that anyways. So, like, to me, that argument is moot because it doesn't relate, because the Secretary couldn't have done that anyways. Like, that wasn't within his power.
Exactly.
Like, they can go to Congress and say Congress should forgive personal loans for small businesses, and I would be okay with that.
And that's a separate thing though.
Yeah, or they could make an executive act like the HEROES Act that would allow some secretary to forgive that if they felt it was necessary.
For small businesses.
Yeah, not like
Yeah.
the PPP loan forgiveness that was for large
Right.
corporations that didn't need it or deserve it. But that's a whole different issue. I don't even know if they bring that up. But again, that still isn't relevant either. Like, because that's a whole different thing.
Yeah,
Like,
'cause-
when they're trying to make the decision, they really can't use that as a justification for their decision. Well, they can do whatever they want, I guess, but
yeah, but
that
they
isn't
shouldn't.
what it makes
That's-
sense. Yeah.
Yeah, and like, yeah, it's just not in the scope though, like you said. It's not within
Yeah.
their scope.
So they couldn't have done it even if they would have wanted to, anyways.
Yeah. It's just not related.
No.
And then some people argue, like, oh, what about people who went to tech school or whatever? Like, I think they should be given loan forgiveness too. Like, you know,
Did they not qualify for federal loans?
I think,
guess? I don't know about Texas. I don't know
well,
how that
I
works.
thought it was
but-
just, I thought these loans, from my understanding, were for like graduates or like people with like masters and stuff, like people who went to graduate school.
the loan forgiveness.
That's what I thought. Yeah, that's what I
No,
thought.
it's for like I'm getting it if it
Oh,
goes
really?
through. Yeah, just the 10,000, but like
Okay.
for my nursing degree. So it's all. I think it's any degree. I think it's just any federal, as far as I know. I guess
Oh,
I'd have
like
to look into
FAFSA
it,
and
but
stuff like that?
yeah, yeah. So it won't be my
Oh, okay.
personal student loan.
I
So
don't know where I thought I heard that, but okay.
no. So I guess like I
Okay,
think
that
that might
makes
also be a misconception is that it's complete student loans. But no, if you have private student loans from a bank, that's not getting forgiven. It's only the federal loans, which is why
right.
it won't affect much of anything because again, the federal government
Yeah.
isn't going to be hurt by doing this. If anything,
Yeah.
it'll just help the economy. But
Right.
because again, if people have private student loans, they're still going to have to pay those. Those aren't going to get forgiven. So
Right.
for those people who have private and federal, it still helps them. Like they will be better off. And so even if maybe they wouldn't be able to, but they won't be like better off in the way. And in my opinion, it shouldn't matter if they're better off. That's a better thing, anyways. But apparently, they make it seem like you can't be better off, otherwise the government can't do this, which is
Right.
that is stupid because that's the whole point of having a government is to make the people better off. Otherwise, what's the point of
Right.
the government? To make us
Yeah.
worse off, or to keep us the same, stagnant? No, that's not the point of a government.
Well, and some people think the point of the government is to tell you what to do, and
No, that's
I mean,
not
no,
what the
that's
government is supposed to do at all.
yeah, and that kind of thinking doesn't lead to good things within the
No, that
government.
just leads to authoritarianism or fascism. Like,
Exactly. Yeah.
anyways, we'll listen to your favorite judge here.
Up on the Chief Justice's and
Oh,
Justice
no.
Alito's questions,
not
if
at
we're
all.
thinking about how to interpret the statute and we're trying to think about the context of the statute in interpreting it, the word waive in isolation, one thing, but it doesn't use cancellation, so that cuts the other way. I take your response to that. But then you're thinking about contextually how it all works, it fits together, the fact that there will be winners and losers, big winners and big losers, relatively speaking, if the executive branch has this kind of authority. People who didn't go to college, as the Chief Justice said, or people who had paid off their loans, who say what they did to pay off their loans, and they're getting no relief because of the timing of the situation. And if Congress were doing this, Congress could and would, no doubt, would hear about all that and factor all that in a way that a secretary could not, especially without notice and comment. Should any of that factor into how we think about whether to give a broad reading to waive or a narrower reading to waive, given the context?
No, I don't think that that should factor into how to interpret the statute. I think instead, as this court usually does, it needs to consider that text on its own terms. And I don't see any way to read the provision to waive or modify any Title IV provision to mean, but only do it a little bit, only in response to minor emergencies. It would actually be perverse to suggest that when there's a big emergency that might necessitate broader relief, the secretary is more disabled from acting. Instead, that's the language in the statute that's meant to empower the secretary and to ensure that he has whatever tools are necessary to fulfill the statutory purpose, to ensure that borrowers are not left worse off. With respect to these concerns about whether there's room to take into account other interests beyond student loan borrowers, there are avenues to go to Congress for additional relief to implement other programs. There's been unprecedented levels of COVID pandemic aid, as I mentioned. And I think to suggest that the secretary here should have told borrowers who he had determined were at massive risk of default and delinquency in record numbers, that he wasn't going to use the authority under the HEROES Act that's tailor-made to prevent that result would have been an irresponsible thing to do. So again, I think that this really comes down to Congress's judgment that there should be authority to provide the benefit within the context of this program. Obviously, there are additional authorities and benefits that can be provided under other programs.
Separate question, the student loan issue is a major public policy issue without regard to COVID to begin with. obviously, and how to deal with that and the burdens it's imposing on people after they get out of college who have massive student loans to pay back. Obviously, a huge public policy issue that was being considered before COVID. Should that factor in to how we think about this? In other words, this is something that was on the table, being discussed, being debated, and then all of a sudden, this public policy idea is attached, that was being proposed and pursued before the pandemic's attached to pandemic legislation. Matter at all?
Pause.
I think
This is just like almost conspiracy.
Well, shouldn't they have thought of that during the abortion debate? Because wasn't abortion a legislative topic at the time when they made their ruling? So shouldn't they have left that up to, well, I mean, they're going to claim that they did because they gave it up to the states but no, that's not, they aren't making like they're just contradicting themselves. They're hypocritical is what it is. Like they'll make decisions that they feel their people who put them in power want, which I mean, I know Trump is the one who got them in there, but it wasn't like Trump was, like there's obviously other people who wanted them in there too, like different groups, lobbying groups that wanted certain judges in there to make certain, I mean, yes, like the Supreme, or no, not the Supreme Court, obviously the legislative branch has the most power because they should be making the laws, but there also are just, and I've kind of wondered, how it must feel. Like I feel like, then this is just my theory, I guess, but I kind of wonder how it would feel to be a legislator right now in what I would think could be like just not this specific time frame, like not just 2020, but like probably the past couple of years and then a couple more, just being the like least effective legislative period of time. Like they aren't getting anything done. They aren't helping the American people. They're hindering the American. Like this is going to go down in the history books. They're going to be on the wrong side of history. They're just going to be looked at as the least effective people of our time. Like, do they not? I mean, and maybe they don't care. Maybe they know that, and they're like, that this is better for them to be ineffective because it helps their lobbying interests groups, which it probably does. But like, they like history is still gonna, like, I mean, unless they win, I guess, in the victories right history. But I don't think that greed is gonna win in the long run. The temporarily it seems to be, but long term it usually fails. Like we've seen people overthrow monarchies before. Like just history, usually the monarchies don't win. So I mean, if you want to be on the monarchy side, then that's your choice. But
at the end of the day, there's like more of us than there's of them type of thing.
Yeah, for sure. There always will be. Because to be the monarchy type person, you don't have multiple people in control. You are the one in control, and you want that power for yourself.
Yeah, or you have like a few people in control.
Yeah, but you still would never have as much as the people, because that would not be a monarchy. That would be
a democracy.
Yeah, which is what it should be, but that's not what they seem to want. But
and like he's really trying to imply like, oh yeah, like this is just an excuse. COVID isn't related to student loan debt at all. Like that's just so ridiculous.
Yeah. Well, and I think he's trying to say, since they were like, obviously, I think well, I know Bernie for sure mentioned it during like when he was running in the primaries, I think. And then I don't know if Biden did when he was running. Well, and I think Biden mentioned something about student loan forgiveness when he was running as the candidate, the DNC candidate. So like that may be there. But I don't think I ever heard Congress talking about it though, or like any legislator talking about, we're going to debate student loan forgiveness. So I don't know what unless they were secret talks, but I don't really, that isn't relevant then, because why are there secret talks in the American people's government? Like why are Because that wouldn't be a national
And-
security concern. Forgiveness of student loans. You can't say that that was secret talks because that was a national security. No, it's not. Like, how could
like I
it
said,
be?
it's conspiracy.
Yeah, they're just trying to do it so they can rule their way. Like, the thing that's what some of their arguments are. They're trying to throw, especially like things that don't relate. Like, I feel like they're just
Yeah.
throwing this in here so that when they make their ruling, they can be like, well, this is why
This
we
is why.
ruled this way. But it's like, no, because it doesn't relate. And I like this lawyer a lot. She's really good at
Yeah, she is really
being
good.
respectful, but being like, no, this doesn't.
Right.
Like, this is why this wouldn't. But I
She's
mean, at
doing
the end of the
pretty well.
day, yeah, at the end of the day, it doesn't matter what. Like,
It doesn't matter
if
how
they
good
have their
she
minds
is.
set already, then it doesn't matter what she says. But
Right, 'cause
hopefully they wouldn't. But
like these hearings are kind of a waste of time to a certain extent, because like they already have most of them already have their minds made up,
they shouldn't.
and like
but,
they shouldn't. They should not. The whole point of the Supreme Court is to not be partisan.
Yeah,
But
100%.
it is. It all
It
is.
is, yeah. But we'll listen to her.
Yeah.
Or did you have more to say? Or no?
Well, I was just gonna say, yeah, like I'm impressed with how well she responds to some of these like dumb
Oh, yeah.
questions.
Then we'll still hear.
I think that it's really hard to
other
think
side
about
too,
how that
but
should work as
I
a
think-
matter of statutory interpretation, and specifically what kind of burden this court would be putting on Congress if it goes down that road. If you put yourself back in the shoes of the 2003 Congress, it couldn't necessarily anticipate exactly what would be the subjects of political discussion and debate at the time that the COVID national emergency pandemic hit. And so going down the road of suggesting the meaning of the statute could change or it should be interpreted in an atextual way because of current conditions, I think would basically disable Congress from being able to take the kind of action we have here of trying to ensure that the executive can act quickly with pre-authorization in an emergency to forestall massive student loan default.
Last question, can't resist on Justice Gorsuch's earlier questions. If it were party-specific relief and it went up to the Court of Appeals and you had sought an emergency injunction and the Court of Appeals and the Court of Appeals ruled against the government on that, would you then follow that in that circuit or not?
I think as a practical matter, we generally do follow that in the circuit. I want to be careful here because
You might not in the future.
Well,
you can admit it.
Our general practice is yes, we treat it as binding within the relevant circuit. But again, the concern here is that actually it's imposing on us an obligation to follow it throughout the nation.
And if you came up to this court in an emergency application and we said you did not have a likelihood of success, I think you said earlier you would follow that. Why would you follow that?
We recognize that this court has authority to resolve these issues for the nation. So
Even
the
though
same
there are
kind
only
of-
two parties in the case, you would say we're going to follow it for everyone else and not force every other affected individual to come to court. Do you think every future administration will have that same approach?
Well, I think that they would likewise understand that even if the relief didn't formally extend beyond the parties in the case, obviously the precedential force of this court's decisions in a given area rule for the nation.
Thank you.
Justice Barrett?
I want to ask you about universal vacatur. I just want to ask you one thing about the statutory language on waive or modify that I wonder whether it's an indication of the scope of waive or modify. So the secretary has authority to waive or modify to ensure that affected individuals are not placed in a worse position financially in relation to that financial assistance, so in relation to their debt. So you agree, right, that we're not talking about a worse financial position generally. We're just talking about in relationship to the debt.
That's correct. That too often collapse, obviously, because if you are distressed financially, it might mean that you're having trouble paying your mortgage or paying your rent, buying your groceries, and paying your debt. But yes, the function of the HEROES Act focuses on your position with respect to your ability to repay your student loans.
So it seems to me that that language in relation to that financial assistance suggests that the relationship would continue. But the waiver or modification here severed the relationship to the debt so that it no longer exists. So why would that be consistent? I mean, doesn't the statutory language in relation to that financial assistance presuppose an ongoing relationship that might be modified but not completely ended?
No, I think that that would be reading in limitations that can't be gleaned from the text. What we understand the statute to be focusing on, and specifically looking at the subparagraph here that justified this act, making sure that student loan borrowers are not worse off with respect to their loans, that functions as a matter of their probability of being able to actually make their payments. And this actually relates to some of the questions that Justice Gorsuch was asking about better off, worse off. You know, imagine a student loan borrower, for example, who before the pandemic had her affairs entirely in order. She had a 0% chance of defaulting on that debt. But then COVID hit, her life has been disrupted, her job was disrupted, inflation is at record levels, she's having trouble making ends meet, and now she has a much higher likelihood of not being able to pay her student loans. In that situation, HEROES Act relief, if it were to operate even to completely eliminate her debt so she doesn't have an ongoing relationship with it, it would just restore her to her pre-pandemic relation insofar as her risk of default and delinquency. She was 0% before, and now she'll be 0% after. And so it doesn't inherently make her better off within the meaning of the statute.
Thank you.
Justice Jackson?
Just wanted to quickly circle back to the fairness point. I guess I'm wondering whether or not the same fairness issue would arise with respect to any federal benefit program. So I'm thinking about the fact that as a result of COVID, we had massive infusions of money given to various companies, organizations, clearly authorized because Congress said do it. I'm wondering whether that would be unfair to people who didn't own a company or somebody who didn't have a nonprofit and wasn't getting that money. I just don't know how far we can go with this notion of, to the extent that the government is providing much needed assistance to people in an emergency, it's going to be unfair to those who don't get the same benefit.
Yes, that's exactly right. And what I would say is that is inherently an aspect of what Congress authorized in the HEROES Act as well. It specifically thought about this situation, what to do about student loan borrowers who are impacted by a national emergency, who might then end up in a worse position with respect to their ability to repay. And Congress made the judgment, you can give them relief. And with any benefits program, there are going to be others outside the context of that particular program who aren't getting the benefit. But I don't see how that could possibly provide a basis to just say that you're paralyzed in doing what Congress intended to ensure that the class they were focused on gets the relief they need.
Thank you, General. Mr. Connolly?
Mr. Chief Justice, and may it please the court. This case turns on the same issue as Nebraska versus Biden, whether the HEROES Act authorizes the debt forgiveness program. It does not, as this court has already heard. I'd like to focus here on 3 issues specific to this case. First, the HEROES Act is the Secretary's only excuse for not adopting the program through negotiated rulemaking and notice and comment. If that act does not apply, there is no dispute that the program is procedurally improper. Second, on standing, the government makes one argument, that if respondents prevail, the Secretary won't provide debt forgiveness to them under the HEROES Act. But that isn't the proper inquiry. Respondents need only show that there is some possibility that the relief they seek will prompt the Secretary to forgive their debts. On that question, there is no debate. Debt forgiveness is a top priority of this administration. The parties agree that the Secretary can forgive debts under the Higher Education Act, and the Secretary has never denied that he may follow the proper procedures and forgive respondents' debts after his current program is declared unlawful. Finally, on the merits, Congress did not authorize the Secretary to create a $400 billion debt forgiveness program behind closed doors with no public involvement. The whole point of negotiated rules.
I thought they did. I thought Congress did decide that.
Well,
Am I
I
misunderstanding?
think he is claiming that since it's $400 billion that they wouldn't have. I think he'll go more into depth on that, but
like how it's too much.
yeah, I think that's
Like for Congress wouldn't have approved that much, basically. Okay.
I think so, something like that.
So like, yeah, just more conspiracy. That's great. Behind closed doors.
Yeah.
Yeah. Okay.
rulemaking and notice and comment is that the individuals most affected by student loan regulations, like the respondents, must have a meaningful voice in the regulatory process. But here, the respondents were deprived of their procedural rights and their finances suffered. Brown got nothing and Taylor received only $10,000, even though high-income individuals making more than 5 times as much got $20,000. The law requires that the secretary give respondents an opportunity to be heard. The judgment below should be affirmed.
Mr. Connolly, has this court ever held that the notice and comment provisions of the APA can establish are enough for standing in a case like this?
Yeah, I would point to Summers. In Summers, this court held that an environmental organization had standing to challenge the Forest Service's approval of the Burnt Ridge project. And because the Forest Service approved that without going through notice and comment. And that environmental organization had standing because there was some possibility that if they went through the proper process, that the Forest Service would change its mind and wouldn't approve the Burnt Ridge project. And I think it's the same thing here. If the secretary goes through the proper process, there is some and does negotiated rulemaking and notice and comment, there's some possibility that he will change his mind and forgive our debts.
Were the procedures in Summers applied in Summers?
Were they implied? I think it was.
No, applied.
Oh, applied. In that case, yes, the court said, the court found it was drawing a distinction between why they would have had standing in one place and wouldn't have in another. And the reason that the group ultimately didn't have standing is because they had settled it. But the court said that if Burnt Ridge had still been on the table, that they would have had standing.
Doesn't your theory of injury rely on the assumption that if the HEROES Act isn't there, or if there's a problem with the HEROES Act, the administration would necessarily have done the same thing under the HEA?
No, I don't think so. In fact, I think the program will look quite different once it does go through negotiated rulemaking and notice and comment.
No, I guess I'm asking you, you seem to be assuming that if you get the relief of invalidation of the action under the HEROES Act, that the administration would necessarily move forward, because you said it was a top priority of this administration, that they would necessarily do the same thing or a similar thing, meaning provide debt relief to people under the other legal avenue. And I mean, I can imagine a world, if you think of a hypothetical, in which the secretary believes that that the department only has authority under the HEROES Act. Here we are in the midst of a pandemic. The intention of the department is to provide this relief in the context of the emergency, and that if we don't have an emergency, and that if we're not in this circumstance and we don't see the HEROES Act there, then they would not move forward. So I think you kind of have to convince us that the administration would have provided this sort of debt relief under the authority you point to that you say has the procedures that were not provided.
Two responses. I think the best evidence for this is the nature of the program. The program applies to 95% of all borrowers. It's not remotely tailored to individuals who are suffering from the pandemic. And the reason is because this is a program that's just designed to help people who are in need of debt relief. And on the authority point, the parties are in agreement that they have the power to do this under the HEA. And the secretary has never come up here and denied that they won't go through the exact same process, which they should have done in the first place once this program is declared unlawful.
Except my biggest problem is you've shown me nothing to suggest that if they have to or will go under HEA, that they're going to deprive you of due process. They're going to let you be heard. What Justice Jackson was getting to is you could be heard and not accepted. I mean, your position could be rejected. Then we'd have to look at that program and decide if that program fits the HEA requirements and the arbitrary and capricious standard. But there is no injury that you're suffering unless you get a speculative new plan that goes into effect You have no proof that if a speculative new plan does arise under the HEA, that you're going to be deprived of notice and comment. And you certainly can't say, if they rule against that interest and you've had notice and an opportunity to be heard, that it was arbitrary and capricious. So I'm at a loss as to how you have standing, because there is no notice and procedure required under the HEROES Act. The only way you can win is if you strike down this program completely. And that means that you don't get an opportunity to be heard, but nobody else does either.
The secretary created a $400 billion debt forgiveness program.
Now, you're arguing what the state's arguing. I'm asking about you.
Sure.
You as a student, once the HEROES Act, your $10,000 student is going to get nothing. He's not going to get $20,000. You strike it down, he gets nothing. Neither does your person who wants something. This is so totally illogical to me that you come into court to say, I want more. I'm going to file a suit to get more, but I know I'm going to get nothing.
So the secretary created a massive debt forgiveness program. And he says that he's doing it one time and one time only. He said this in his brief, in his declarations, on his website. And in the reply brief, he said he took costs into account. And so if we miss this shot, we will never have another opportunity to get
No,
debt
you can.
I don't know if that hurts you or helps you. I mean,
HEA.
it seems to hurt you to suggest that. I thought your argument was if we strike down this program, then we know the secretary is going to try again under the HEA, and that's the relief that we are seeking, the procedures that exist under that program. So if he's done, if we strike it down, isn't Justice Sotomayor right that you're in a much worse position by bringing this lawsuit?
If he completes the program, but we are trying to stop this program so that it can go through the proper process, so that we have an opportunity to comment and urge the secretary to forgive our debts. Right now, Ms. Brown has $17,000 in student loan debts, and she's not getting a dime of debt forgiveness. And if this had gone through the proper process, there's some possibility that we would have had our debts forgiven. And if in Lujan, what Lujan talks about is this is why procedural rights are special. Because the agency can always come in and say, you know what, we would have done the exact same thing even if you would have had that process. Your injuries aren't redressable, they're speculative. But that's why procedural rights are special.
Do you rely, to what extent do you rely on the fact that your clients include an existing student loan borrower? And that you have it a little different than one that is not. In other words, it's not speculative in the question of how would that person be remedied, but it is another borrower. You're asking for notice and comment, and during that period, if it's granted, that would it would entitle you to raise, why the limit, whatever the credit limit is, that should be changed. Is that? I think your challenge is to make that sufficiently particularized and non-speculative. The problem with standing jurisprudence for something that looks for something concrete and particularized, it's also very academic. A dollar of injury and you're in. Hundreds of millions that they can't trace directly to the agency action, and you're not. So what is it that makes the interest of your client who has a $17,000 loan, how is that sufficiently concrete and particularized in the context of something that the government would address if it can't do what it's doing now?
Sure. So I think it is critical that we're here representing borrowers. She has student loan debt, and it's not being repaid, and those are concrete interests at stake. So this is not someone off the street who is upset that his or her taxes are going to go up. That there's no question that'd be a generalized grievance. But here, if you look at the scope and the purpose of the program, it's to help student loan borrowers. But instead of doing this through negotiated rulemaking and notice and comment, they carved up the lines and they did it all in secret. I'd point the court to page 31 of the government's reply brief. On that page, the government said that it had extensive discussions with banks and ultimately decided not to forgive FFEL loans. That's the type of thing that should be happening on the
Mr.
public
Connolly,
record.
aren't you really fighting Congress on this one? The HEROES Act specifically says no notice and comment, no negotiated rulemaking. Specifically says there's going to be an emergency. So we're waiving those procedural requirements. So, you know, you might think that Congress made a wrong call there, but that's Congress's call.
Because when Congress wrote the HEROES Act, the waivers and modifications have to actually be authorized by the act. You can't just label something a waiver or modification and skip through negotiated rulemaking and notice and comment. Right there, subsection D, it says the negotiated rulemaking requirements shall not apply to the waivers and modifications authorized or required by the act. It doesn't say anything that the secretary labels a waiver or modification is authorized by or required by the act. And so we recognize that Congress did create an exception, but the waivers and modifications actually have to apply. They have to actually be authorized by the HEROES Act.
Mr. Kiley, what are the limits of your theory? Could someone who finished paying their loans off, right last year, sue because they were disappointed that they weren't included for reimbursement?
No, I don't think so, because there's no mechanism by which the Department of Education can write those borrowers a check. And so their injuries are not redressable. Here, there is a mechanism under which the secretary can forgive Ms. Brown's debts, forgive Mr. Taylor's debts, and that's the difference.
What about the Chief Justice's lawn care person who doesn't go to college, starts a lawn care business, but as the chief said, this person has some fairness concerns and feels like this shouldn't have happened and kind of level up or level down and wants to level down?
Sure. Again, the Secretary of Education has no power to give any money to that individual or do anything like that. And so even if he could come up with a concrete interest, it couldn't be redressable.
Could have persuaded him not to do it would be, I take it with the fairness concern and the hypothetical the chief posed you. I think it would have been to say, well, this isn't fair. You're not doing this for me, so you shouldn't have done it for anyone. But you're not taking the position that would be
No, he would not, because you have to have concrete interests, has to be particularized, can't be abstract. And so
it's not just the getting shut out of notice and comment.
Correct. These individuals have concrete interests. There was a $400 billion debt forgiveness program that was created, and the respondents have debts and they're not being forgiven. And if it had gone through the proper process, negotiated rulemaking and notice and comment, we could have argued that our debt should be forgiven too.
The suggestion is not that the Secretary of Education should forgive on behalf of different banks loans to lawn service companies. It's that is a consideration of other Americans in a comparable situation who will not get that sort of relief that maybe the Secretary should have taken into account. And that if we had notice and comment rulemaking, that maybe that would be a consideration that would come forth. Or maybe if Congress were involved in this expenditure of $500 billion, that might be something that they could consider.
Right, and I would also point to the negotiated rulemaking statute. This is a unique statute. The Congress said specifically that it wanted all of the individuals who are affected by the Title IV loan process, student loan borrowers, universities, everyone, it wants them to be involved in the process. And it strengthened those requirements in 1998. And so the idea, I think, that right after doing that, really strengthening negotiated rulemaking, that Congress said, yeah, you can create a $400 billion program on your own in secret without any public involvement. It just doesn't seem possible.
What is the limiting principle? I mean, there are many programs out there. People say, well, I ought to be covered by that, and I wasn't. And we certainly don't allow everybody to come in and say, just because I would have a right to comment if this law were struck down, I therefore have a right to bring a suit. I mean, how is this? I understand maybe you have the one client that has a student loan and one that doesn't, right?
Right.
Well, there's a clear difference between those two situations, isn't there?
Sorry, they both have student loan debts right now. Brown has $17,000 and Taylor has $35,000.
Okay. Well, Well, what principle should we look at to try to limit the universe of people who can, otherwise you get people who are
Right.
interested in any kind of law at all. And so I'd have something to say that the secretary might find of interest and notice and comment. And so I should be able to sue to block what's there now.
I think you have to look at the scope and the purpose of the agency action. Was the individual's concrete interests at stake? If they're doing something that has no relation to what you're complaining about, your concrete interests, then it's coming out of left field, and that person isn't going to have standing. Or if there's no possibility that the secretary is going to give you relief because we're dealing with topic A and you're coming in here on topic B, then that person isn't going to have standing. But here there is no dispute. The secretary is trying to give release to student loan borrowers. That's the nature and the scope and the purpose of this act. And instead of figuring out, okay, among this universe of student loan borrowers, who's going to get what, how much, instead of doing that on the public record, they did it in secret first.
So for purposes of standing, as distinct as to who can comment, because anyone can comment,
Right.
For standing purposes, it has to be someone who was in the class of people who could have been afforded relief. Is that?
Yeah, I think that's a fair way to put it. You have to have concrete interests. It has to be particularized, and that's what we have here, I think.
And if I understand your theory, it's once you strike down this program, then the secretary just uses authority under the HEA. Is that the nature of your theory, which would include notice and comment and negotiated rulemaking?
The HEA gives the secretary
But the
power.
theory is that the secretary will just switch to another statute.
Well, I think that's focusing. You look at the agency action. You look at the facts on the ground of what's actually happening.
But you're striking down this program. That's the whole point of your being there. You're trying to, this program is not, right? You have to strike down this program to get any possibility of notice and comment under another statute, right?
Right.
So you have to strike down this program, then you go under another statute. And where you do get notice and comment. That's the theory.
That is correct. The HEA gives us a right. They have to go through negotiated rulemaking and notice.
Right. I mean, usually when we give standing for procedural violations, we're talking about procedural violations within a particular program, right? We're not talking about, if you have a problem with the procedures relating to one program, you can just come in and strike down the program so that you're in another statute entirely.
Well, I don't think it's right to focus on the statute that they're using as an excuse. When you look at what we look at,
the statute they acted under.
Well,
and it's a statute that says you don't have to use notice and comment.
Well, I think we focus on the agency action at issue. So in Lujan, the Lujan footnote 7, the agency is proving a dam. In Summers, the agency is tearing down a forest. Here, the agency is doing debt forgiveness. I think you look at the action. I would point to.
Suppose there were no HEA. Suppose it was this statute or nothing. Would you then say you still have standing because once you strike down this program, the secretary would go back to Congress and get a new statute?
No, I don't think so. At that point, there would be no possibility that he would go back and give us.
Well, yes, there is a possibility. He goes back to Congress and says, this is terrible. Nobody can get loan forgiveness. So I'll go back and get a new statute.
That relief would be coming from Congress. The way you look at the redressability is whether there's some possibility that the agency will reconsider its decision. And here, the decision was the debt forgiveness program. And so.
Keep going. Sorry.
And so you look at the agency action, and the other line of cases I would point to is the structural separation of powers cases. In those cases, you focus on the agency action. You don't look to see whether the actions or the act's restrictions on removal are injuring the individual. You look at whether the agency's actions are injuring the individual, and I think it's the same thing here.
What's your best case, if you have one, for your answer to Justice Kagan's question about you going under a different statute? Or are you aware of such a case?
I guess a few responses. First, I would go back to the ones I just mentioned, Lujan and Summers. None of those cases focused on the statute at issue. They looked at the action. Lujan footnote 7, the dam example. An individual who is living next to a dam, when they approve that dam without going through the proper process, that individual has procedural right to challenge that. When the agency approves the dam, they're approving it under the Federal Power Act. When the individual is going to get relief, he's getting it under the Endangered Species Act. And I think what that footnote shows and what that example shows is that the statute really doesn't matter what they're acting under. What matters is the agency action.
Well, let me ask you about the evidence. What evidence do you need as the plaintiff coming in claiming standing that the agency would have proceeded under this other statute? Because it's not a world in which, they overlap so entirely that if we take one away, they're automatically in the world of HEA. They would have to actually elect to operate in that other world. And so this goes back to my very first question to you, which was about, aren't you relying on the assumption that if the HEROES Act falls, this agency or this administration would pursue the same course of action under this other statute?
Sure. A few responses. First, if you look at the nature of the action, it is applying to 95% of all borrowers. It's not remotely tailored.
Do you have evidence that they've said, even pursuant to this litigation, for example, that if the Supreme Court strikes this down, we're going to pursue the same relief under the HEA? I'm asking about what do you,
Sure.
Is it enough for you just to identify another path? Don't you have to at least have some evidence that the administration is going to move in that direction?
So, yeah, so again, I would point to the nature of the rule, that it's broad-based, it's not tied to the pandemic. The second thing I would point to is that there's all sorts of evidence. During the campaign, they were talking about doing broad-based debt relief. It wasn't related to the pandemic. Senator Warren and others passed resolutions urging the secretary to use the Higher Education Act to pass debt forgiveness. Scholars have written about this.
And yet the secretary chose this path. So I guess I'm just trying to say, do we have something from the secretary saying that, we're definitely doing this under all circumstances and we pick the HEA if the HEROES Act falls?
I think that would be a very high burden for us to meet. Because if you look again at footnote 7 of Lujan, when it's talking about why procedural rights are special, what it's saying is that if the burden is on the plaintiff to come back and say, my comments are going to be amazing, they're going to do this, they're going to change their mind, procedural rights are going to be useless. They can always come back and say,
no, but that's change your mind within the context of a particular program. This is Justice Kagan's point. I mean, yes, redressability gets relaxed when we're in the world in which procedural rights would have otherwise existed, and you don't have to, as a plaintiff, show that they would have made a different ultimate determination if they'd heard your comments. Right. We understand that, but what you're suggesting is that same principle of redressability applies to whether or not they would shift to an entirely different legal base of authority to pursue this program, and I've never seen that before.
And again, I think this program, they could have cited section 1082 of the HEA to go under it. They believe they can do it. They've said it in their brief that they can do it. The reason my guess is the reason why they didn't do that is because they would have had to go under negotiated rulemaking and notice and comment. And if you look at the breadth of this program, it's not about helping people who are uniquely suffering from the pandemic. It's helping 95% of all borrowers, and except for the respondents here. And so I think when you look at the nature of the program at issue, plus the campaign statements, plus the fact that they've never gotten up here and denied it, you put all that together, and I think we have a strong, at a minimum, some possibility that they're going to get up when this program is declared unlawful and they go back to the drawing board. I don't think they're going to fold up shop. I think they're going to say, well, how about the HEA?
What's your theory, if any, and maybe I should be asking the other side this, but your theory for why they didn't want notice and comment?
I think because the negotiated rulemaking process and the notice and comment process, I mean, it's a long process, and agencies probably would, most agencies would prefer not to have to do that.
And this is an emergency, and emergency statutes typically do not have notice and comments, do they?
If this were authorized by the HEROES Act, then they could have gone under it, but it's not.
They could have done the good cause exception, though, right?
They could have tried to, but they didn't. And probably because it's not an actual emergency to have to forego notice and comment negotiated rulemaking.
Thank you, counsel. Oh, wait, I'm sorry. I didn't mean to cut you off too quickly. I'm sorry. Justice Thomas, do you have anything? Justice Alito? Justice Kavanaugh? No. Justice Barrett? The same? See? Okay.
Thank you.
Thank you very much. General Prelogger?
Thank you, Mr. Chief Justice. I want to begin with standing again. My friend was asked several times whether he has a case to support this novel theory of standing. He referred to Lujan and Summers. Those cases don't support the theory he's advancing here. In every case where there has been an asserted procedural injury, the plaintiff was asking for the agency to reconsider its decision under the very statutory authority at issue. He's not been able to identify any precedent where instead a plaintiff is able to say, I acknowledge I can't get any relief under the particular agency action at issue. Instead, I'm hoping for some kind of bank shot where if I can hold up the agency in this one area, maybe they'll take a different action under a different statute that will down the road provide me some kind of benefit. And that would be an extraordinary expansion of Article 3 injury in the context of procedural injuries in particular. He was asked whether he had a limiting principle, and he suggested, well, you have to have a general interest or stake in the subject matter of the dispute, but I don't see how that limits it at all. Go back to the cases he cited, which involved environmental plaintiffs. And imagine a scenario where you have an environmental plaintiff who is interested in pollution, and the agency has decided to regulate water pollution. Now, that plaintiff doesn't actually have a stake in water pollution, isn't harmed by it, but the plaintiff thinks that if it can hold up the agency from regulating water pollution, maybe the next priority or goal will be to go after air pollution. I think that if a plaintiff came to court and pressed that kind of claim, it would be clear that it is far too attenuated and can't possibly supply a basis to allow this universe of plaintiffs to newly assert these kinds of procedural injuries or substantive injuries with respect to agency decisions that have not been made. He said that they have a concrete interest in trying to have their debts forgiven. If that were their interest, there were several straightforward mechanisms to try to vindicate it here. They could have challenged this plan as being arbitrary and capricious on substantive grounds to say, you should expand the plan to include us. Or if for some reason they really wanted to have this under the Education Act, they could have gone to the secretary and filed a petition for rulemaking and said, give us relief under the Education Act. But instead, their argument here is that the secretary can't provide debt relief. That is a really anomalous way to try to vindicate an interest that they claim they have in loan forgiveness. I've been thinking of it effectively as this Rube Goldberg theory of standing, where instead of taking the most direct route, you've set up this complicated route to try to get what you want, all in service of being able to smuggle in a substantive challenge to the HEROES Act for borrowers who are not hurt one bit by the Secretary's decision to grant relief under that act. Finally, I want to respond to his suggestion that instead the Secretary should have proceeded under the Higher Education Act here. I would think that at the very least, if they were going to ask this court to recognize a cognizable Article 3 injury on that basis, it would be incumbent on them to explain their wholly unexplained position of why they think the Secretary could do this under the Higher Education Act. My friend has suggested that that's what this program was actually designed to do, but this is a pandemic-related program. It specifically focuses on the national emergency circumstances that have had profound financial effects on student loan borrowers, and the Secretary acted to try to mitigate those financial harms from COVID. That's what the HEROES Act was made for. It is a perfect fit for this kind of circumstance, and it explains why the Secretary chose to provide this relief to those who were harmed by COVID, just as the forbearance policy was put into place right at the start of the pandemic, similarly on those COVID concerns. And then finally, I know that we have had hours today on the legal issues in this case, but I do want to step back for a moment and focus on the stakes of this case for the tens of millions of student loan borrowers in this country who have had devastating financial impacts based on this unprecedented pandemic. Over the past 3 years, they have benefited from the critical relief of the forbearance policy. That's an unprecedented form of relief, but it was very much needed in this circumstance to ensure that we did not see a deluge of default and delinquency on student loan debt. And it's undisputed, my friends have not disputed, that when that forbearance policy ends, and it can't continue indefinitely, Once it ends, there are going to be millions of borrowers who are in a worse position because of COVID with respect to their ability to repay their loans. 90% of the borrowers covered by this plan make less than $75,000 a year. And the Secretary documented the extreme impacts that COVID had had on their financial affairs. Already, 26 million people have applied for this relief, and 16 million people have been approved to receive it. For those Americans, this is a critical lifeline to ensure that they are not subject to the severe negative consequences of delinquency and default on student loan debt. And the relief for these Americans has been held up by 2 student loan borrowers who don't even have standing and whose claims fail on the merits. So we'd urge you to reject their claims.
Thank you, General. Mr. Connolly, the case is submitted.
Okay.
Oh, is that it?
That was, where's it? But hold on. Just, whoa.
Whoa, you're big. Okay.
But yeah, okay. That was student loan. Well, one of the yeah, I don't know. Like, I guess I feel like they don't have any stand-in either, but it's hard to know what decision they're gonna make.
Yeah, I mean,
Because sometimes they
Oh.
seem to be helping like the person who was on the other side, like making his arguments for him, and I was like, I don't
right.
really think you guys should. Like, I don't
That's
think the
not the
judges should be
point.
making the arguments for either side. They should be neutral and just listen
Yeah.
to the arguments. And if the person
Yeah,
can't
and
make
ask
their own
questions.
argument, then their point fails. You shouldn't help them make their argument.
Right. Yeah, like it's
And I
not
don't
your
know.
job.
I still want to listen to the Biden versus Nebraska one because that one seems like it's going to be more about the HEROES Act and why they're claiming that the HEROES Act doesn't cover it. So that would be interesting to.
Yeah.
That one's just a longer one, so we didn't have time to do that one today, but we can do that one sometime. Either
Yeah.
this weekend, next weekend, the weekend after. We can figure it out when we want, and we still have other
Yeah.
ones we want to listen to too.
Yes.
Especially the longer ones, we want to take little breaks though in between them, just because they get
Yeah.
long. But yeah, it'll be interesting to see. They're just because I know they'll have to. I think they'll have to, like, even if they ruled this one was invalid, they could still rule that the other one was valid though.
So there's 2 of them?
Yeah, just like for the internet
Oh, the internet one.
cases, there's the
Okay.
Twitter one and the other one. I don't remember. Did we watch the Twitter one or did we watch the other
No.
one?
We watched the section 230.
Gonzalez.
The Gonzalez versus
Yeah.
Google, yeah.
Google, yeah. So Twitter and Google. And then there's Department of Education v. Brown, and then the Biden versus Nebraska.
Yeah.
So, and then there's also a bunch of
I
other
would
cases.
I kind of want to listen. I know it's not recent, but I do kind of want to listen to the abortion one. The
Yeah.
Roe v. Wade.
That we can listen to that one sometime too, because would be interesting to see what because they already had
I
their
wanna see
minds
what their
made up when they
arguments
were. Well, yeah, because
Yeah.
that one they for sure already had their minds made up. I don't
Oh yeah.
think that they
This
were
one-
even listening to their arguments.
I
Then
feel
that
like-
one.
Yeah, I feel like this one, like most of them had their minds made up, but there
Oh,
was maybe
yeah,
like one or
probably.
two who were actually genuinely trying to ask questions and figure it out.
Yeah, especially the ones who were trying to make that guy's argument for him. I'm pretty sure I already
Yeah.
know what their decision is on the student loans.
Right. I mean,
And like
what, we have a
it doesn't even
6-3
make
right
sense
now, right?
either with his argument, because like his whole argument is hinging on if they overturn this, make it unlawful, that the secretary is gonna go, they're still gonna forgive loans. But I'm pretty sure if the secretary were to do that, there would be more legal cases against that. So
Yeah.
it's not like, I don't know what these students, I don't know if they're being paid to be accomplices in this to like fight against it, or if they genuinely think that the government's gonna give more forgiveness for student loans, but they're
Right.
not. I'm pretty sure if this gets overturned,
Yeah,
then
they're
they're
not.
done.
Right.
So like they literally
I don't think Congress will
like,
forgive
and
them.
she had $17,000 and was getting 10,000 forgiven, but now she's gonna get nothing. So she's gonna be stuck with that. Like she would have only had $7,000 left
Yeah.
on her student loans.
Yeah,
but
which
she-
is terrible. I mean, it's a lot of money still, but it's
I don't know if I
terrible
think
for
she's
student
from
loans.
Texas, so I don't know if that tells you anything. But...
I mean, well, yeah.
And then she could have been paid to be like a wit or whatever.
Right.
And maybe she wasn't. Maybe she genuinely,
Maybe she really thinks they're gonna rewrite it.
yeah, under
Yeah.
the whatever other act that was. But
Yeah.
I don't know. I don't think. I
What, the
think
HEA?
if it gets, yeah, I don't remember what it's called, but
The
I'm
Higher
pretty sure if
Education
it,
something
yeah, Higher Education Act, it must be.
Act.
But
Yeah.
I'm pretty sure if they rule this as unlawful, I don't think we're gonna see any form of tuition for. I could be wrong, but I just highly doubt. And I don't think that that would go unchallenged. I'm pretty sure that would be challenged too.
Yeah.
So it's not like it'll be, yeah. That case just seems kind of
Yeah.
dumb, I guess, because it isn't helping the people who are filing the lawsuit. It isn't going to help them. And why would you argue a case that will make you worse off? Because it is going to make that person worse off with the 17,000.
Right.
Like it's not going to make you better off. Like I guess in theory, but the fact is that you don't have any proof that they're going to even reconsider forgiveness if this gets overturned. So that kind of blows up your whole case, in my opinion. Like it'd be different if the secretary if you guys had gotten him on the stand and he was like, yes, if this gets overturned, we will pursue a different avenue. Then yes, I could understand. But you just claim that was too high of a burden. How is that too high of a burden? Like you literally ask him, and if he says yes or no, then you have that is not too high of a burden. Right. It's just
I just kept getting frustrated. They're like, what about the lawnmowers? And I'm just like, oh my god.
Like the person couldn't have done that anyways if they wanted to. That wasn't within their scope.
I mean, everyone got a stimulus check pretty much. Everyone applied at least.
Well,
like I got my
you didn't even have
stimulus
to
checks.
apply. I think they just sent them to you.
I had to apply.
Oh, maybe I did. I guess I don't. Maybe like the first.
Maybe
like I know there was
depend
one
on
where
the
they just
state.
sent them to you. Like you didn't have to apply for all of them.
Yeah, I think there was one where they just sent it.
Oh, okay.
But like there were a couple of them that I applied for. Well, I applied once and then I got a couple of them.
Oh, okay. Yeah, I guess maybe I don't remember. It feels like forever ago, but
yeah.
And like their whole argument about how it isn't specific to like it was for 98% of borrowers.
Oh
and
my God.
But COVID affected every single borrower. It affected everyone.
Yeah.
So you can't claim that this isn't helping like how would you narrow it down to like COVID affected everyone, regardless of if they lost their jobs. It still affected the economy overall, and clearly with inflation, like it affected everyone.
Yeah.
So how you couldn't even technically narrow that down. Like every borrower should. I mean, yes, I guess there is that one person's
and like pretty much
that he isn't getting any, but I guess I don't know. Oh well, I think there is an income limit though. Like I think if you make over like 150,000 a year or something, then you don't get any forgiveness. Which I mean, I guess I wouldn't care if they did though. Like I wouldn't be against them getting forgiveness, but I mean, you probably aren't financially affected, but you might have been. I'm not going to say you weren't, but
I mean, yeah, and
it's still like to argue on that basis is just.
I mean, there's people who like got COVID and like couldn't work because they had COVID. Or they had to go to the hospital because of COVID.
Yeah, and there's still people who have like long COVID who still can't work or do anything. And I guess like I'm not saying that all those people who have long COVID have like student loans or like anything, but COVID affected everyone differently. So you can't really. It would have been hard to try to narrow down.
Exactly.
And then there's a whole argument that they skipped the talking part. Like what is that called again? The like where they had to hold an open committee or something, like where they had to do like a chance to get people to talk. I forget what they called it. They kept calling it the something, but the act said they could skip that part. So when he kept saying like they had to have like the talking part so people could weigh in on it, no, they didn't. Not with this act. They didn't have to. So like he's trying to claim that since they didn't hold
he
that.
never said why they have to. He just kept saying they have
well,
to.
I think generally with that.
I mean, he was giving like examples of other
leaving?
complete.
Not much longer. Were you leaving? Yeah. Okay. What?
You gotta watch right
No, I know I'll be up in a second. You guys can go. Um, but yeah, I think generally they have to do like a rule, like whatever that's called. Like they have to hold like a hearing so that people can weigh in on
Yeah.
the rule. But with
And they-
the act in a pandemic, with the Heroes Act, they did not have to. So he kept arguing that they skipped, but they didn't have to do it regardless. So again,
Right,
that
'cause-
didn't make any sense.
And then he was doing that example with like the people who were building a dam and it was like interfering with someone's house or something like that.
Oh, like the court case that he said would help his case.
Yeah. I was like, that's not the same thing.
No,
Like
it's
that they're
like I think he was saying that
was
the
it the
COVID, like the borrowers who didn't get any relief are like the person who housed it. But in that's different because that committee, I'm assuming, like they had to hold that process of hearing everyone. Again, the Heroes
Well,
Act, they
yeah.
don't have to.
And you can't just like, bulldoze someone's property.
No, yeah. I
You
mean, I
know?
see what
Like,
he's
that's kind of
trying to say, like with it,
I
but
see what he's trying to say, but it
yeah.
doesn't connect to me.
No, I think he's just trying to say the precedent of it, though, not really like the situation. Obviously, like the
Oh, like
precedent
of
that was
having the
set by it.
yeah,
Yeah,
but there's a
but again,
reason
it
for the
doesn't relate.
precedent in that case. Like there's more of a
Yeah,
reason for it in that case.
yeah,
Than there
and
is in
either
this
way,
case.
like with that case, if they would have had to hold that part, I forget what was it called. Why? Let me look it up. I'm just gonna go back to it because I want to just say what it is. No, we won't. What was it? Who? What? What was his Chansey? No, that's a Pokemon.
The Pokemon franchise revolves around 1,015 fictional species of collectible monsters, each having unique designs, skills, and powers. Conceived by Satoshi Tojiri in early 1989,
what are you listening
Pokemon
to?
are
I'm not.
creatures that inhabit the
Alexa,
fictional Pokemon.
thank you. Stop. You're
Oh,
you're
that was
okay.
Alexa just going off.
Yeah, because we talked about Pokemon.
Oh my god.
Always listening. You know that
That's
Bezos,
creepy.
right?
That's why I don't get one of those.
Hold on. Oh, the blah 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 blah. Where is it? So you look at the agency action. No, you don't. Well, okay, you do, but la la la. What was it called? Like where they have like everybody has a chance to go in and weigh on like the ruling, if that makes sense.
Okay. Yeah.
Oh, comment and negotiate. Notice and comment and negotiated. What basically
Oh,
notice
okay.
and comment is what it is. But again, the Heroes Act, they don't have to offer that notice and comment. I mean, I'm not saying that they shouldn't, but they also could if they really feel like they deserve more, then why don't there's another avenue for them to pursue where they could have went to the government and been like, well, you can go under this other process as well.
Yeah.
So they didn't need to hold up this student loan forgiveness to
Right. They could have
achieve what they
just
wanted.
brought up a new.
Under the HEA, they could have gone under
Yeah.
that. Also, they could have been like, well, you have like you owe it to us to go under this to the borrowers who didn't qualify under this,
Right.
instead of
Yeah.
being like, we're gonna stop everybody's forgiveness. Like
Yeah.
that's where it all. It's just a joke, I guess, overall. But
Yeah. It's just something to mess things up.
yeah, to be a win for Republic, so that they're not stealing the taxpayers' doll, even though nobody is gonna be fucking affected. It's not gonna.
Right.
Nobody's taxes are gonna increase. Nobody's losing money.
Right.
It's just a joke, a complete joke, and
It's
people are
money the
falling
government
for it.
already has.
Yeah, and it's not gonna affect the budget because they don't need a budget, not on this type of stuff, because it's.
Right.
I mean, you could argue that the resources of education would be professors, but I don't know. How about we encourage more people to become professors so that we have more professors so that that resource isn't short?
Yeah, it's true.
But then the whole, I would say GOP is attacking education, right? Even though they're claiming they're not attacking education because they're passing legislation to give parents more choice or control over education. Because
Yeah.
Parents who have never taken education courses should definitely be deciding what's going on in the classroom, but
Oh yeah, totally.
not those teachers who took 4 years and sometimes master's degrees to become teachers. No, they don't know what they're doing.
Oh yeah, totally. Yeah, no, of course. The teachers don't know anything. That's why they have degrees and masters and PhDs and
because they're
whatever.
woke. Obviously, that word.
It's
woke.
the liberal woke agenda, of course.
Yeah. But yeah, okay.
Okay, cool.
Anyways, so cool. That was the thing challenge Supreme Court. Yeah.
Yeah.
So
what was it? Department of Education versus Brown, right?
yes, yeah. So
Okay.
and then I don't know what we'll be back tomorrow, but I don't know like what we'll be doing. But
yeah, we'll figure it out.
Yeah. So otherwise, thank you for people who watched or do watch in the future the recording. But otherwise, yeah, just we'll see y'all some other time.